we go. And I think that quick zoom in on our screens tells us that we're live. So hello, welcome everyone to the May Fireside Chat. It's already May, which is insane to think. But for those of you who've already been at multiple conferences this year, I have as well, which makes it feel like the year's even flown by faster. So not sure where everyone's joining us, but I'm here in very sunny St. Petersburg, Florida. And the weather's finally turned. We're getting beautiful weather, and we're able to be out in the pool over the weekend. So for those of you in snow country, hope spring is headed your way as well. I'm Becky Teal. I head up our community efforts here at Huntress. And today we've got a really unique spin on the Fireside Chat, and that we're talking about why MSP should have a lawyer in their corner. And more specifically, why maybe looking for an industry-specific lawyer might be impactful in your business. So I am joined by two lawyers and an MSP. I was trying to think last night how to wrap that into a strange joke. Couldn't finish it, so we'll just get started. Julie, would you please introduce yourself?
I'd be glad to, Becky. My name is Julie Machal-Fulks. I'm a partner and co-founder at Monjur. We do contracts as a service for our MSP and SaaS clients, and I'm happy to be here.
Awesome. Thank you. And I know it is storming there today. So if we lose Julie periodically, you've got some weather in your area today.
I do. It is Texas in the spring.
Fantastic. Well, thank you for joining us today. And Eric.
Becky, first, thanks for having me. I'm really excited for the next hour. I'm Eric Tilds. I am an attorney and also a recovering MSP owner. I was very fortunate to be able to be a partner in a 250 employee MSP that we exited to a multinational MSP. And today I operate a law firm where about 90% of my clients are MSPs or MSSPs, help them with custom agreements, things like that.
Perfect. Thank you, as always, for your time today and for joining us. And Dustin, I think that's the best chat. And if somebody can win that, I will personally send some Huntress swag your way. So we might have to vote on the end at best punchline. Dustin.
Yeah, so I am Eric and I were joking the other day. I'm on my second MSP. Something's wrong with me that I just dove headfirst back into it. Clear Guidance Partners, 29-person MSP focused on law firms, actually. And I've also been known to dabble in cyber insurance as well. I am licensed in all 50 states now. So kind of unique intersection there.
That's an interesting career pivot. On the insurance.
I'm going to need years of therapy.
But for which side? Because those both sound like very stressful industries.
Yeah. Both.
Well, perfect. So we did build a bit of an outline, but to those of you in the audience, this is also an opportunity to dig in, ask questions, challenge things that we might come up with, or even share your own experience in some of these areas. So the thing that I kind of wanted to start with in our outline and what we're talking through on specialists versus generalists. What are the benefits, or are there benefits or reasons to hire an industry-specific lawyer versus a general law practitioner? Eric, if you want to get us started. Thank you.
There's I think that there's room for both, right? And when you're talking about agreements and contracts that are specific to MSPs, specific to IT, it's always a good idea to have an experienced attorney like Julie or myself help with those contracts, right? Real estate leases, things like that are sort of a dime a dozen, use your business attorney for it if you want. But when you're talking about things that are unique, right? And you think about things that we do as MSPs, and a lot of these contracts revolve around data and data protection and privacy and things like that. You generally don't want your business attorney working with you on those.
I would just add to what Eric said that it is also important to find a lawyer that you feel completely confident and comfortable with. And, that part to me is the most important part. So if you have somebody that you've been working with for 20 years and you want to use someone like Eric or someone like me to help shore up their experience, we're usually happy to do that. There are certain topics that it really makes sense to get somebody who has that experience and specializes in those areas of the law. I know that both Eric and I have 20 years of experience in the MSP space. And with that comes a lot of war stories and a lot of clients going through a lot of different problems. And there's just no substitute for that experience.
And I can add just anecdotally, when I get a hold of a new client's MSA, for example, I always ask where it came from, because I'm always curious. Did they put it together themselves from Google? Did they get it from their buddy in their peer group? Did they get it from their insurance company? Sorry, Dustin. But I'll tell you that when MSPs put together agreements on their own, if you were to rank it on a scale of 1 to 10, it's usually about a 2 or a 3, right? If they had their business attorney do it, it's much better, but it's usually only about a 4 or a 5. Right. So the goal is to get it to be that 10. And that's something that the MSP specific attorney can certainly help with.
Yeah, I have a fun little story. Eric just jogged my brain of kind of talking that generalist versus specialist. So again, I've been doing the MSP thing since 2008. Always used my business attorney for leases, right? Eric just said real estate. Well, luckily back in 2020, MSP was growing really big. We were pumped. So signed a lease on this big, huge new office in January 2020. At the time, though, we had just a really badass real estate firm that we brought on as a client. So I said, you know what? I'm not going to use my general guy. I brought them on. The property management ended up buying us out of our lease. So historically, I don't think we would have gotten much of anything. We walked away with a huge check, basically like 18 months worth of rent, to where we had effectively almost free, for the duration of the thing, because we had the real estate attorney and she had done this and knew about it. So to me, that's one of those things of, the previous leases we had signed, we probably would have gotten a little bit back. It wouldn't have been bad, but it's like Eric said, right? It's that 5 out of 10 lease. This was the 10 out of 10 lease because we had that super specialist in our corner. So there's, depending on, do you need that extra, do you need to get to 10 out of 10, get the specialist?
So similar to, say, a healthcare provider, like you don't need the specialist for everything necessarily if that's not the route you want to take. But there are certain parts of the business element that having a specialist is really important. I have to believe, as Huntress, we hear mostly the security side of things, but I have to believe that that's especially important in a security realm of liability whose fault is something, that having somebody who understands what that means and the nuance to it would become really important. So one thing that we talked about a little bit in our prep call was that importance, like the agreements thing, especially, that in the end, if you help them write their MSA, do you become their IT counsel then if something is ever called to court or to be reviewed? Like, do they come back to you? Do they take it? Like, if you wrote it, are you helping support it behind the scenes then?
In my practice, yes. Once I write an agreement, if a customer wants to redline it, if they have questions, if they want to change it in the future, then yes, they would typically come back to me. And that's the other important thing. And I know we talked about this the other day is that, you hire an attorney like Julie or an attorney like me who's done this a million times and can almost do it in their sleep. Not only are you going to get a better product, but you're going to get a better product faster. And if you're paying us by the hour, if you can have us do something and it takes us 2 hours and have someone who's not quite a specialist, it'll take them 4 hours, right? It's usually a better proposition to have the specialist who helps you with the agreements take care of it until it's time to change them.
I would say that I agree with everything Eric said. The only caveat I would append to that is I definitely will help people with questions about the agreements we drafted and that sort of thing, but I don't always help with collections, simply because there are lots of folks out there that can help you with collections. And sometimes having somebody like Eric or somebody like me work with you on that is like killing a mosquito with a bazooka. You can do it, but you shouldn't. And so I don't want to speak for Eric necessarily, but there might be some things that we don't necessarily help with or that you might want to get a specialist for. But for the most part, if it's in support of the agreements we drafted, we certainly can help.
Mosquito with a bazooka might be the best saying.
Right.
I like that one.
It's still not a punchline to 2 lawyers and an MSP walk into a bar. We're waiting
not quite. And So far, attendees, you've been quiet, so please know, like, throw questions in here or put them in Q&A. This is a really cool opportunity to ask lawyers questions about anything that we discuss or beyond that has to do with your business, knowing that, like, there might be some things where they go, you need to speak to your own attorney about that. But feel free, please, to throw things in the conversation here. So let's move on. So yesterday or 2 days ago on our prep call, I got to ask you guys a lot of questions about things that I wonder about, which is usually what these fireside chats turn into. We talked about MSAs versus SOWs versus SLAs. Who wants to kick it off and kind of give me what are the difference between those and kind of what should or shouldn't be considered when writing those? Knowing that we'll dive into the MSA piece much bigger in a little bit.
Julie, you want me to start?
Yes, go ahead.
I'll give kind of the 30,000 foot view. So the 30,000 foot view is, and I think Julie and I are in agreement on this. The MSA it contains all the legal terms and conditions under which you operate your business. It covers the legal terms and conditions for everything you do, whether it's selling managed services, selling professional services, selling resold product, anything from a legal perspective that needs to be addressed should show up in the MSA. Now, the MSA doesn't obligate your customer to buy anything. It doesn't obligate you to do anything, right? That all shows up in the statement of work. I call them a statement of work. Some people call them proposals. Some people call them managed service agreements. I don't care what you call them, but for purpose of this conversation, we'll call it a statement of work. And in the statement of work, that's the agreement that commits you to doing something. To performing managed services, to performing professional services. That contains all the business terms, the what you're doing and how you're doing it and how often you're doing it and how much you're charging for it. And then the SLAs, we could talk about that for forever. So the SLAs are the sort of the standard of care that the MSP is expected to abide by. In other words, depending on how it's drafted, it could contain things like response time, resolution time, uptime. Personally, and I think Julie and I share this opinion. We're not big fans of SLAs, right? I'm okay with service level objectives, right? Things that don't really bind an MSP, but just more guidelines from the response time, not the resolution time. I don't like it when MSPs are asked to commit to resolving things in a certain period of time because things are outside of their control. Many things that MSPs do are outside their control. So that's kind of the high level overview. I'll let Julie or Dustin or Becky dive into for the details.
To just build on what Eric said, I completely agree about SLAs. And my general rule of thumb is if you're looking at the SLA and a customer relationship, things aren't going well. You cannot manage it to the SLA and have a good relationship with your client. And furthermore, as I said on our prep call the other day, if you have a ticketing system or a problem management system, the response is immediate. No matter what the issue is, you get a response in 10 seconds that says, we have acknowledged your problem. And so from a legal perspective, it's just not really that critical. And what I find is in the market, you don't need it. And so a general rule of thumb in the legal industry is if you don't need it and your customers aren't requiring it, don't promise it.
So Dustin, MSP perspective, have you ever had somebody push back and demand an SLA or like strongly request
so
one?
I guess a couple thoughts on that. The first thing I'm going to say is this is the part where it'll be fun. Julie and Eric are going to tell me how I'm doing it wrong. So a couple of pieces on it is the response thing. I agree because of the automatic piece, right? You just have a workflow in your PSA. It responds great. We check the box. So our SLAs say specifically to start work. And we use that as a selling point. And we say people, oh yeah, they're going to give you an auto response that hits the SLAs. I hate the resolution thing because we all know, every fix is either 15 minutes or, a week to figure out. You can't predict that kind of thing. So ours specifically are to start work. But yeah, around asking, it comes up. I don't think I've ever redlined our SLAs since I've been doing this since 2008. But the two times that I've had the conversation come up around, hey, you guys failed your SLAs, both of those customers were gone within a couple months. Julie hit the nail on the head, right? By the time you're getting that point, it's a bad relationship. You're either getting fired or worse. So, if you can get away with not having them in there, I like that. But anytime that conversation goes around SLAs, that's what I tell people, where it's like, if you don't like these SLAs, if we're to the point where we're talking about that, you're probably about to fire me anyways, right? The other big one for me is I see so many MSPs, hey, we're 6 guys, we do 24/7, we have SLAs. Like, dude, you have a guy with a beeper in the middle of the night. Chances are good he's not getting up. So this time, being my second MSP, is we did the polite version of it is we call it screw you SLAs. From 10 p.m. to 7 a.m., there's no guarantee of anything. Like, you're welcome to call, but my guy's probably sleeping. He probably turned his phone off. Everybody who sits there is like, oh, you need 24/7. No, you don't. There's so many companies where you can say, look, we're covering kind of into the, late evening. That's enough. Stop committing to 24/7 SLAs. You're setting yourself up for failure. The 99% of customers that think they need it don't. Even with, I said, we work mostly with lawyers. Julie and Eric can say, you guys know lawyers. Oh yeah, we need people around the clock. No, you're generally good and till 10 p.m. And then on the weekends, we have on-call coverage also. That has never been a problem. So that my big takeaway for today. And again, Julie and Eric, I'd love to hear your opinion. For the love of God, MSPs, stop committing to 24/7 SLAs. Whenever the majority of you aren't actually doing it, it's an on-call person. That doesn't count. You're setting yourself up for failure.
I Dustin, I tell people all the time, if you don't have a help desk manned 24/7, don't put this down. If you do have it, if you do have an outsourced help desk that's promised to man the desk 24/7, 365, then by all means, put it in there. But don't say you're going to do it if you're not. I tell people all the time, I'd rather you write nothing than write the thing you're not doing.
Yeah, and even if it is just a service level objective, right, and you're not going to breach a contract because of it, don't commit to things that you're not going to commit to, right? And I represent some very, very large MSPs who do have their own 24/7 manned help desk. And great, tell your customers that, right? That's a differentiator for the really, really large guys. But for those that don't, or like Julie said, for those that might outsource it, particularly if you offshore it, I'm not necessarily certain that I would commit to anything.
So, because once it's in writing, it is a legal obligation. So I would imagine that starting with small and adding things as needed to win a new customer, to keep a customer, but adding things that you can 100% guarantee 100% of the time. It's almost like you can't just hand somebody a giant list of things you do and then try and pull it back later.
That's
right. Probably better to, somebody said it really well, of stop over promising on your SLAs. Awesome. So we've got some questions coming in, which is perfect. All right, Michael, let's see. In the past at large law firms, I've used resolution SLAs with tails. So 80% of, for example, of incidents will be resolved within X hours or days, which leaves a 20% cushion for the stuff that takes longer and some that even falls through the cracks. This doesn't work for MSPs that support SMBs. Have you ever seen somebody use like a tail of like...
We have that actually. It's funny he says the 80% because that's what our threshold is for SLA credit. So Julie and Eric, is that a good idea?
I generally don't recommend it, right? Whether it's 80% or whether you say that you're going to average out all your tickets over the course of a month or however you're going to skin that cat. Again, I am not a big fan of committing to resolution time SLAs. Because we all know, even if you can control it 80% of the time, 20% of the time you can't, right? And what happens if there are a few tickets in that month or a few tickets in that period of time that are just linger for forever, like Dustin said, for a week? Set the expectation with your customer that you can't commit to that because you can't control that.
And I would just add to that, everybody that I've ever seen that has this type of provision, they're not tracking it adequately. And so this is yet another example of, I saw that face, Dustin. They're not tracking it adequately. So it's just another example of promising you're going to do something that you're not actually doing. Because who's calculating? Did we really resolve 80% in in X amount of time or X amount of days? And who's really giving the credit if the client's not asking for the credit? If the client's not raising the red flag and saying, you failed in your SLA, we want a credit, are you proactively giving them the credit that you promised to give them? And if not, again, go back to the, to the adage I said earlier, which is don't promise to do stuff you're not going to do.
So I got a question for you guys that made me think. Is I'm one of those people that always reads the vendor contracts end to end. So I see a lot of them where it's like upon client request, right? If we fail the SLAs, client has to request. Is that a fair strategy, or is that setting yourself up for failure?
Like Julie said a dozen times today, are you really going to track that, right? And for most MSPs, the answer is no. So for most MSPs, you want a proactive report from the vendor of their uptime. A lot of vendors will put it on their website, right? They will proactively tell the world how they're doing from an SLA perspective. And that's obviously preferred. If they're not going to do that, then I would always demand that it comes from them, not the other way around.
So just a heads up to those of you in the audience, if you see your chat disappear, it's because I moved it over to Q&A so that we remember to get to it. So I'm not deleting your comments. It's just we move it over to Q&A so that we have a better question list. I had somebody ask last time. I was like, oh, no, I didn't. That wasn't offensive. I didn't delete it. I just moved it over. So one question, how often should we have our MSAs reviewed? Meaning, how often should you, lawyers, look at those MSAs?
I always tell my clients every 6 to 12 months. That's once you have a solid MSA in place. If you're using the MSA that you didn't get from a Julie or a me or an MSP-specific attorney, then have it reviewed right now, right? And then get on some regular cadence with your attorney. Now, just because I say every 6 to 12 months, maybe something comes up in the interim, right? And if that's the case, then I'm reaching out to my clients in less time than that.
I agree with that time frame, Eric, and barring any kind of regulatory action that requires a wholesale review, and just so everybody knows, like, this isn't sort of esoteric possibility. This is really happening all the time. So right now, Congress is considering, or I guess just passed the initial phases of a ban on non-compete agreements. And the question is it going to extend to non-solicitation agreements as well? And if that happens, then every single one of my master services agreements is going to have to be revised, because it has a provision in it that says clients can't solicit our employees, the MSP's employees. And so if that law passes in September, as they expect it to, and if it does contain that prohibition on non-solicitation provisions, then no matter where you are in the 6 to 12 month process, we might have to revisit things. And so I would completely agree with Eric. At a minimum, people need to be looking at things once a year, because with the new privacy and security and data protection laws, as well as the international implications from GDPR and things like that, you need to be looking at these things pretty regularly.
And by the same token, you need to be looking at your vendor agreements equally as frequently. Right. I mean, most vendor agreements, and I see it all the time, especially those vendors who have access to your data or your customers' data. You want to make sure that those are updated regularly. You want to make sure the vendor has notification obligations. You want to make sure the vendor has timely notification obligations in the event that there's some sort of exfil of PII. So all the things that apply to your customer MSAs likewise apply to your agreements with your vendors.
Yeah, and I'll throw in from the MSP side. It drives me nuts. I'm gonna cite Reddit on this one. Sorry, but all the stuff, all the Reddit posts where it's like, so and so screwed me on this contract, and it's like, dude, you didn't read the contract. That's the, it spelled it out very clearly. There's a lot more vendors out there that will negotiate and let you, redline contracts than most MSPs realize.
Every vendor will.
Yeah. So go through, push back on some of that stuff. Maybe you're not going to get everything that you ask, but we probably have, I'd say, like 90 to 95% of our vendor contracts we've done red lines on to ask for specific stuff, usually around notification, termination, repeated breaches, or just the crazy, the non-disparagement stuff. No, I'm not going to sign that. Like, red line it out, and they usually accept it.
That's a good for the follow-up question then is, let's see, Mitchell, we use Eric for our MSA, and something you brought up before is negotiating with vendors on their agreements with MSPs, specifically around to better help protect MSPs in the case that the vendor is breached. Can you expand on that?
Yeah, look, if the vendor has your personally identifiable information or that of your customers, you want to make sure that if there is a breach, and look, there's two things that can go wrong with vendors. Either they have some exfiltration of information, or their service fails, right? Either way, both are equally important, and you have to address both. Most vendor agreements will address what happens if their service fails. Very, 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 very few will address privacy and data protection obligations unless someone like me, someone like Julie makes them address it. So it's important because it's the supply chain, right? They provide services to you, you bundle those services together, provide them to your customer. If they do something wrong, it's going to affect your customer, who usually gets left holding the bag. You do as the MSP. Right. And there's very, very little that Julie or I could do to eliminate that risk. But the idea is to have that bag that you're left holding be as small as possible. And hopefully it's an insured risk. Right. So you're not necessarily out of pocket. But it's really, really important. There are far, far too few MSPs out there, even my own clients. I impress upon them and they still don't do it, that have all of their vendor agreements reviewed.
And in addition to that, you want to make sure that your MSA is identifying that as a possible risk, because we can't control it. And so, yes, you want insurance, as Eric said, to help you minimize the impact of those risks. But you also want to make sure you're disclosing to your clients, hey, this is the implication of my relationship with this third party. And I don't think that MSAs that are prepared by non-specialists really do that adequately.
Yeah, that's been a big push that I've seen the last year. That's coming up more and more from, Julie and Eric, insurance, the whole 9 yards. A piece that I think a lot of MSPs are a little bit oblivious to, those vendor liabilities.
So back to the 6 to 12 months, really good question here. If changes are being made every 6 to 12 months, individually signed MSAs don't scale well. What are your thoughts on evergreen T's and C's / MSAs? Julie?
So I do advocate for evergreen terms, master terms and conditions, coupled with renewable service specific terms. And so basically you enter into a master and you let the client know that you are going to be reviewing it on a regular basis and that you have the opportunity to make changes, and that you will tell them what those changes might be. And then the service specific terms get renewed once a year and revisited and represented to the client. But it's been my experience that many of the provisions in a master don't need to be revisited every year, and they don't change that significantly that often. And so I typically recommend that the master stays in place until the relationship has terminated, not just one set of services.
And it's really important, that just pushing up on Julie's last point, that you want to make sure that your MSAs are very specific and that they don't allow a customer to be able to terminate an MSA while you are still obligated to deliver services. I see that a lot, where the term and termination of the MSA is not tied to the actual services that you're doing. And it's super important to make sure that that for as long as you're providing services to a customer, you're protected by the umbrella of the MSA. I'm a big believer in online MSAs, right? Referencing them in hyperlinks for a bunch of different reasons. But number one, it's reducing sales friction, right? You put a statement of work in front of the customer, you reference an online MSA, you have them sign off on it. A lot of customers, as we know, are not going to go and look at your MSA. Those that do go and look at your MSA are going to say, oh, it's online. They're probably not going to change it anyway. And the few that do want to negotiate, then you negotiate it. It's not a big deal. But that way, when you not that when you change it online, it it applies retroactively, because it generally doesn't. But you can then catalog your old MSAs and just say, hey, look, if your statement of work was entered into between these two dates, then here's the MSA that applies. And between these two dates, here's the MSA that applies. And make it really, really easy for your customers to agree to your terms.
I agree with Eric. I like online terms as well. I have seen an increase in the ability of my client sales teams to close deals. I've seen a huge reduction in the amount of red lines that we have to do. And honestly, it gives your team less of an opportunity to make a mistake. And so if you have a link and you know this is my master service agreement link and it goes on the bottom of every single one of my orders, it's very difficult to screw that up. And I can't tell you how many clients I had before we started advocating for online terms that I would say, okay, bring me the contract formation documents that I'm about to have to fight about. And they would say, oh, we forgot to give it to them, or we can't find it, or any number of problems. And so I completely concur that to the extent you can use online terms effectively and successfully, you should.
Yeah, when we sold our MSP to a multinational MSP, I then became general counsel of our. We lost her. I
that was a risk.
General counsel of our.
I just lost video for 1 second.
Okay, good deal.
And we used to deal with about 3,500 customers a year. Wow. And what we found as soon as I put our MSA online and properly referenced in the statements of work, our negotiations went down about 80%, as opposed to sliding the MSA across the table and asking them to sign it. It works.
So in that instance, then, is it on them to review the MSA separate from you? So is that why that works? Is because you're not having to sit there and go through it with them in person?
It's not necessarily you don't have to go through it with them. It's just that it's easier, that you don't have to show it to them at all. You're showing it to them as a link in their statement of work. So it's incumbent upon them to go look at it if they want to. And I don't know if, people are inherently lazy and they just don't want to do it, or they don't do it, or I don't know why. But I will tell you that it certainly works. But the caveat is, number one, you got to make sure it's done properly. Like Julie said, you got to make sure it's referenced in your ordering documents properly. And number two, don't just stick your MSA that you're using with signature blocks and everything up online and say that's it. It's got to be a different version. It's got to be a prepared version of your MSA to be posted online.
And many of our clients are inherently resistant to that sort of a concept, because they've been trained by people like me and like Eric, frankly. You need to get a signed copy for every single client. And so, as these times are changing, it is sometimes scary for MSPs to migrate to this online model. And I can understand why it's important that it's formed correctly. And, you want to make sure that you're working with somebody who knows what they're doing to help you make sure it's formed correctly. But if you do it right, it can really save you a lot of time and heartache. And also it can help you with negotiation. I tell my clients all the time, tell this person who wants to pay you $500 a month, my lawyer is very mean and she hosts my MSA online and she will not let me make any changes. And I'm sorry, because you don't want to pay me to negotiate a deal that's making you, something less than $500 a month. It just doesn't make any sense. And so in some of those instances, you can use that relationship with your counsel as a buffer between you and a prospective client.
Yeah, think about the cost on it. Lawyers are not cheap. Right. So, okay, what size deal does it make sense to even negotiate at all? $500,000, $1,000, it's not worth your time and energy. And that's probably a sign also of this client is small enough and they're already being a pain in the butt. That's setting expectations for down the road. Great. We just, not only are we in the hole from onboarding and everything already, now we just had to cut a huge check to Julie to negotiate this deal. All right, that's probably not a good first step for you with a new customer.
No, so Jeffrey did have a question about a list of MSP lawyers and their rates. I have to believe that lawyer rates are not something that anyone publishes.
Well, there's only two good ones, and that's me and Julie.
They're right here. There you go.
Here's the list.
There you go.
Looking
There's
at it.
two. And Eric did share his contact information in the chat. Julie will as well. If
I
you
will.
want to reach out to them after, they're both on LinkedIn as well. But yeah, they're sharing their information there. So, but the rates piece, I feel like that kind of, so during the prep call, we only joking, a lot of the questions I asked, the first answer was always, it depends. I feel like that's also with the rates piece, that it depends.
Yeah.
There isn't a tried and true there.
I will say, as somebody who works with a lot of lawyers and has used a lot of business lawyers for various this, that, and the other, like, you get what you pay for to a degree. So if you go and you find that dirt cheap lawyer, there's a reason that they're charging you dirt cheap on it. So kind of keep that in mind too. That
and like I mentioned earlier, I'd rather pay a lawyer $1,000 an hour for an hour of work than pay a different lawyer, $350 an hour, and it's going to take him 5 hours to do. Right there is some correlation there.
Yep.
No, very fair.
And Becky, going back to the last conversation as well, like around red lines. So talking minimums. And then the other thing we talked a little bit on the prep call was what we do is we kind of have a pre-approved cheat sheet in the past where our business attorney has said, like, on our MSA, we can change these. I literally have a Word document that's like, here's these 6 things he signed off on. So that way it's not every single time. Is it stuff we want to change, limitation of liability, we can increase it a little bit, things like that. It helps a little bit for when you're negotiating on that stuff.
And
but again,
lawyers call them playbooks, not cheat sheets. Dustin.
Playbooks. There you go. Sorry. our playbook.
But look, depending on your involvement as an MSP and who's presenting the MSA to the customer, not only should you talk about internally what can be changed and what can't be changed without talking to a lawyer, but also it's a good idea. And I spend a lot of my time doing this, and that's training my clients and training my client staff, training the sales staff. Again, back in my Logicalis days, when we had a couple hundred sellers around the country, I would spend about 3 weeks every summer and go and visit all of them. And train them about, what the MSA is all about. What are the common points of negotiation? Why is this language there? Right. And not that you need to make them into junior lawyers, but they should be able to help reduce some of that friction between the company and the customer when it comes to some of those discussions.
So, Julie, you had a really solid point in the prep of why are MSAs important.
Well, they're important because it helps reduce the risk, and it identifies the expectations for what we plan to deliver and what we plan, frankly, not to deliver. And so it's a roadmap for what the overarching relationship should be like. Did I get it, or did I miss it?
Yep. You did. The way you put it there was that you don't want to bet your business every time you perform services.
Oh, I think that actually belongs to Eric. I think that's
Eric.
Yeah.
Dang it. All right.
That's definitely an Eric statement.
Yeah, and look, if you are doing work without an MSP or an MSA rather, then you are betting your business, right? If something goes wrong, and if it goes horribly wrong, and it will one day, right? Every MSP has gone through that, and if they haven't, they will. But if you're doing it without things like proper liability caps, then you're betting your business, right? You're putting your business on the line every time someone walks out the door to go do something, or every time someone picks up the phone to answer a question.
It feels kind of like the breaches thing these days, right? It's a question of when, not if.
Yeah.
So even if they have no standing, somebody can hire a lawyer, they can try to sue you, I was talking to somebody the other day that their client's making a demand for $100,000. Like, yeah, it didn't seem like it was based in reality, but nothing's stopping them from doing it.
Yeah, absolutely.
We like to say any idiot with a filing fee can file a lawsuit.
It's true. Any reason, anytime, or no reason at all.
Exactly. And so that's one of the ways your MSA can help you. In an MSA, and I'm sure Eric's are very similar, they contain mandatory arbitration provisions where the client can't just sue you for no reason. And that helps you because then you can reduce the risk that Dustin just talked about, where they think they have a case, but they drag you into court and you have all of these deadlines and litigation issues that you have to deal with, and arbitration may not be faster or cheaper, but it is definitely easier.
So one person asked, and this isn't the first time I've seen a question like this, but do either of you have a high-level checklist on the items that an MSP should put in place to protect ourselves? And then including a don't do list. I'm guessing that is always, it depends.
Yeah, I mean, look, if you look at an MSA, an MSA, at least in my opinion, is probably 60 to 70% boilerplate, right? The problem is a lot of people treat them as 100% boilerplate, right? And they just say, oh, here's an MSA, I'm gonna start using that, instead of really customizing that 30 or 40% that needs to be customized. So are there some high level topics that should be covered in every single MSA? Absolutely there are, right? Things like limitations of liability and warranty and indemnity and payment terms and confidentiality and all of that stuff that should go into an MSA. But in my opinion, that gets you 60 or 70% of the way there. The rest is really dependent on your business.
I can give it. Sorry, Julie, go ahead.
I would just say, as a high level checklist, I would go maybe to the 50,000 foot level and just say, have good documents. I wouldn't even necessarily go down into what needs to be in those documents, but my checklist is have good documents, have good processes, understand what you've obligated yourself to do, and make amendments when you need to. Because if you don't understand what you've promised to your clients in your written documents because you didn't understand the documents well enough when you read them, you are setting yourself up for one of those bet the business issues that Eric was talking about just a minute ago.
Yeah, and not just have good documents, but use the darn documents too, right? I can't tell you how many times, someone's come to me and we've been negotiating something and I've asked the question and they say, oh, well, we've been doing business with them for 3 months now, right? But we're negotiating a statement of work. It makes absolutely no sense. So have good documents and use the documents and use them properly.
Yep. I was going to say, I'm not going to sit here and say I know what good looks like, but I'm going to say I know what bad looks like. And this is the part where I make Julie and Eric cringe. Just a couple things that I see a lot that people do is starting the work before the contract's signed. I've seen a lot of people start up MSPs. Oh, I grabbed this template off of this. I saw somebody share it on Reddit, or I borrowed one from a friend. I will tell you personally, at my old MSP, whenever I ended up taking over dealing with legal and contracts and sales, my business partner at the time had taken the contract from our data center and literally just turned around and put our name on it, which had nothing to do with MSP. It's talking about, IP availability and this, that, and the other. And I was like, dude, this isn't why did you think this was a good idea? And he's like, well, I didn't want to pay the lawyers. So yeah, there's a lot of stuff that I see pretty frequently like that. That's just a really bad idea. Chat GPT contracts, please guys, don't do that.
And Dustin, that's a good point. And, I can tell you that I can look at, and this is particularly from the vendor side, some new vendor comes along and one of my clients sends me their contract to look at. I can tell by looking at a contract and looking at how well or how poorly it's written, how the relationship is going to go, right? Because if a vendor is really buttoned up and really takes care of their contracts and takes the time to put a good agreement in front of a customer, that means that they're paying attention, right? And someone who, to your point, uses a data center contract for MSP work, they're not paying attention to the details, and odds are the relationship is not going to go well. So same thing turning around for an MSP's business. If you are putting a really solid contract in front of your customer, one that an MSP-specific attorney has looked at and revised and made look good for you, your customer is going to look at that and say, oh, these guys know what they're doing, right? As opposed to putting I'm not going to name names, but some other, MSA that you found online, putting that in front of your customer, they're going to think that not very highly of you.
And I like to tell people, you can pay me a little bit up front, or you can pay me an awful lot in the end. So, if you don't want to pay me to write a good agreement for you in the beginning, you can pay me to defend you in the end, but it's going to cost a lot more.
Ounce of prevention?
Yeah, a little bit. I mean, just to share one story, I have a client that wasn't using an agreement I drafted and terminated an end user who threw a phone at the engineer who came to service the account. And the client sued my MSP because there was no termination provision in the agreement. And so the client said, you MSP cannot terminate this agreement because you don't have the right to under the contract. And we are still a year and a half later in arbitration about whether my MSP had the right to terminate because they were using a terrible 2.5-page agreement that they didn't want to expend money for a lawyer to write.
That's crazy.
Jeez. Wow.
And Julie, I'm glad you mentioned 2.5-page contracts, right? Because I'm sure you hear a lot from your clients too. I don't want a long agreement, right?
Why is it so long?
Yeah,
why is it 20 pages long?
My customers are going to be scared of a long agreement. Well, guess what? They're not. Just trust me that they aren't, right? Again, if it's a good contract, if it's well written, number one, it's going to be a little bit long, right? If it's going to be all encompassing, it's going to be long. I'm sorry, it just is. But it's the difference between doing good business and doing bad business. Not all business is good business.
My response to them, Eric, when they ask me why it's so long or can I make it shorter, is what protections would you like to lose?
Exactly.
I didn't put any extra stuff in here. This is all stuff you need.
Yeah.
So you tell me what risk you want to take, and I'll take that language out of your agreement.
Yeah, I don't know about you, Julie, but I don't charge by the word. But to your point, the stuff is in there because it needs to be in there.
Right.
I picture like how much you have to scroll anytime you put like a new update on your phone. The amount of stuff that has to go into that. To Dustin's point, like people don't read most of what you put in it. So wouldn't it be better to be protected than not?
Yeah.
Like, that's because you can always take it out. Like that's where the redlining comes in, right? Like if it's a piece that is negotiable, you can take it out if the prospect
if a customer pushes back and says, why is this in here? It doesn't apply to me. Then sure, we can talk about that. But I'd rather have that conversation than the conversation 3 years from now with my MSP client saying, why wasn't that in there?
Yeah. So the piece that I was the most excited to talk about in all of this is where we're going to end today, because we've got 13-ish minutes left. Liability waivers. So for those of you who don't know, Huntress built out a series of opt-out emails to help you explain advanced security to your end users using an opt-out campaign. That kind of premise of make people tell you no, they don't want to be secure versus yes, I want to give you more money. And when we built it, one of the biggest questions we got asked was, can I have a liability waiver? Basically, if you say no to this thing, you're agreeing that I'm not liable for that. I kind of only half jokingly call it the told you so agreement. What are your thoughts there? Do liability waivers work, and are they worth it? Dustin, do you use liability waivers?
I was going to say, please let me go first on this. So we actually have done one time. This was a couple weeks ago. Was our last on-premise Exchange server finally going away? And we told them, we were like, hey, this is a huge liability. We had some security incidents and stuff. And so I said, we're going to waive it. And that was the final. The guy was like, yeah, if you're at the point where you're having to do that, like we should probably get rid of it. But Becky's I told you so thing, because look at where this is going to go, right? Let's do super simple example. MFA. I don't want to turn on MFA, right? Here's a liability waiver. We all know what's going to happen, right? There's going to be an incident. There's going to be a breach at that point. I told you so. Like whoever has won an argument with their spouse coming back later and saying, well, I told you so, like it's not going to end well, period. If you're getting to the point to where you're having to do liability waivers, to me, that's a bad sign that that's not a good fit for a customer, right? You shouldn't be, if you're having to get in that mindset, to me is something else is wrong, right? So I don't like it. I don't know the legal side of it, but that's my thing is like, if you're an MSP and you're to the point where you're talking about liability waivers for a specific situation, take a look in the mirror, like sit down and think hard about it, because that probably means something else is wrong. You're not pushing hard enough. You're not having the right conversation, or it's a bad customer. Not all business is good business. Like, is that customer, lawsuit waiting to happen, that kind of thing.
Yeah, I mean, Dustin hit it on the head. I mean, you think about other, analogous situations. A long time ago, I took a class to carry a handgun, right? And 95% of the class was talking about how to never put yourself in a situation where you'd ever need a handgun, right? And it's the same thing here, right? Don't ever put yourself in a situation where you need a waiver, right? Now, that doesn't mean that the one-off situations aren't going to come up, and you might want to use a waiver in a certain limited circumstance, but don't make it part of your business practice. Don't make it part of your playbook. Use it only when and if you absolutely have to, if you can't do it any other way.
And I would add on to what Eric just said. This is an important enough event. If you think you need a waiver, you also need to be talking to your attorney about it. And so if you don't think it's important enough to be talking to Eric or me or somebody like us about, then it's not the right situation for you to be using a waiver. I definitely do not provide a waiver that I give to my clients and say, carte blanche, use this whenever you feel like it's necessary, because I think it's a terrible idea and it's a bad way to manage your clients, right? Now, if your insurance company requires you to do it, which 2 insurance companies that I'm aware of do require it. If they do, then call us and talk to us about it, and we'll try to negotiate with your insurance provider on your behalf and explain to them why you don't want it. Because I recently did have a conversation with a carrier where I said, this is why you don't want these waivers floating around. And at the end, they said, you're right. We don't want those waivers floating around. How can we accomplish this instead? And we got a process improvement that tackled the problem rather than this blanket waiver that people seem to want to sign. And so I think that's a good rule of thumb. If you feel like it's such a unique and important situation where you need to have somebody sign a waiver and you want to keep them as a client, knowing what Dustin just said about whether they're a bad client, then it's important enough to hire your lawyer to guide you through
it. So Chris has a really good point here about talking about risk all the time with clients. Dustin, do you try to turn if somebody declines a service that you offer and you were willing to negotiate on that, where does that turn into a risk conversation versus maybe we're not the right fit?
Day one. So we did all you can eat, everything's bundled. We have this great EDR and MDR platform that every one of our customers uses. But that was one of my things. Was my first MSP, we were super a la carte. There was just like, Julie, let's talk about a firewall. Julie, let's talk about MDR, that kind of thing. This time I went all in because I don't want to deal with that. We started using the phrase security first MSP 2019 whenever I started CGP. So my thing is one of those, like, I don't want to fight for those customers where it's, oh, I don't know if I want this. It's written into our contract. They have to enable MFA. Julie and Eric, actually, this is a good question for you guys. My contract says that they have to enable MFA on any IT systems, basically best effort, even if it's one we don't manage. We put it in there, like, this stuff is mandatory. There's a certain baseline of expectations on it. So again, we've only done the waiver thing once. It's really, I'm trying to think on any of the security stuff. We really don't negotiate on any of it. Optionally, we use CyberFox Auto Elevate. That's an optional one, but they still don't get admin rights. They can have a different account to log in and install stuff, but that's kind of a pick how you want to manage it sort of thing. But that's it. I don't want to do the race to the bottom. I don't want to do the waivers and all that stuff. I want all my clients to look, generally the same from a security standpoint. So I'm a bad one to ask. Sorry.
And Dustin, to answer your question, yes. I mean, I require MFA in all of my contracts. Generally, it's written such that MFA is required on 365 and any externally available application. You don't necessarily need it on your internal ERP system or whatever, but definitely on 365 and definitely on anything that's accessible from the outside.
I would say that I don't always put it in, but I have the same conversation that you guys are talking about right now that MSPs should be having with their end user clients with my MSPs who don't require it. So some of my MSPs are saying, I don't even want to ask them to require MFA. And I have this same risk discussion that you have. So, I don't want to, as you guys can tell from my discussion today, I don't want to put something in there that requires MFA if you're not going to enforce it. And so if you're just going to waive it for every single person who objects, then don't put it in as a requirement. But my recommendation to all of my clients is you should require this.
So a really good question just came through that some clients may use a third party for certain services like email, and they do not include email protection. Our solution can only work with O365 or Workplace. Does a waiver apply if they don't want to make a switch to an email we can protect?
It depends, right? Are you going to be like Dustin and say, we are not going to service you because you don't use an email we support, right? Or is this potentially bad business, right? And or is it something in the middle, right? Where maybe a waiver is okay. Maybe a waiver is not the best idea. Maybe you just write into your managed services statement of work that you're just not responsible for anything that comes out of their email system. That's a possibility too. There's 1,000 different ways to skin that cat.
Yeah, my concern as a MSP would be, at that point, okay, we put the waiver in, great, we're protected on MFA, but maybe they go in and somehow get ransomware from that email. Now it hits the network where we are responsible. Like, yeah. I don't know. That scares me.
So one more question. This one's a good one. That if we don't have a list of lawyers, how does someone find an MSP lawyer in their jurisdiction? This Joel particularly is in Canada.
They call up Becky and they say, Becky, who's a good lawyer to talk to?
There you go.
And it's a discussion I have with my clients all the time, right? I'm only licensed to practice law in Michigan, right? I'd imagine Julie is in one or a handful of states as well. And the good thing about the business that we're in is that there's very, very little that's state specific, right? I'm only going to give state specific advice as it relates to Michigan law. Outside of that, if it's not state specific, then we can certainly do it. I mean, to give you an example, when I was general counsel at Logicalis, we had employees and customers in all 50 states. We had one MSA, right, that applied in all 50 states. There's nothing state specific about it. And I think that question was about Canada. Canada's a little bit different in that I have clients in Canada. But what I recommend to them is that I will do the upfront work, but then I want them to go to a Canadian attorney, show them my work and Canadaize it, if you will, to make sure that it's appropriate for Canada.
And similarly, I'm licensed in New York, California, and Texas. And so I have a relationship with someone in Canada. So for my Canadian clients and Canada specific questions, I have a resource in Canada that I work with very closely. But I do have clients in almost all 50 states at this point, and I either work very closely with their existing in-house or external counsel, or I use somebody for those state-specific questions that may arise from time to time, particularly employment-related questions. Mm-hmm. I use a team of lawyers across the country.
Okay, so that answers that. I'm not sure what the last question is. Jeffrey, if you want to give us some more context here, but is there a trial? Is there a trial for MSPs? Also, is it licensed by user site endpoint? So
I think that's for Julie.
Julie Monjur. Is there
for Monjur? So we don't have a trial. We do have a 30-day back guarantee if you're not happy with it. And it is it's priced by the month, no matter how many end users you have or how much revenue you have. So I'm just making sure we covered all the things we said we wanted to cover here, because I know we had gotten through a lot. One piece Dustin, what do you got?
I was going to say, we did not cover the insurance aspect. You almost left off my favorite.
Oh my gosh, yes. So MSAs and cyber insurance. Dustin, take us away.
Yeah, so I'll start off. We covered this a little bit in our prep call. Insurance is starting to look harder and harder about that. Cyber insurance or tech E&O is what an MSP needs. It's not all created equal. We're seeing vastly different coverages around, how much does it cover your services? So my general thing has been the more questions they're asking around your contract, because that's where, most claims are happening for MSPs, the better it is. So if you see one or two questions, there's one carrier that says do you have a written contract and does it have limitation liability? Their coverage is not very good, right? Versus as it starts to get in, do you have these specific phrases? Do you have this, that, and the other? There's even certain ones that require this MSA, that kind of thing. That is very much on the attention of, we're working with a carrier to build a new tech E&O policy. And that's their big thing that's been revolving around, has been 90% of the conversations are around contracts.
And the other thing that MSPs deal with all the time is their customers' cyber insurance applications, right? So Be very, very, very careful when you're dealing with your customers' cyber insurance applications. Make sure that you're contractually bound to help them with those applications, to make sure that you're looping in your MSA. right? And make sure that you have some agreement in terms of the scope of the services you're going to provide to them to help them with their applications. Make sure that they're responsible for the final product, not you, right? We've all heard of the Travelers case and other cases where MSPs are getting in a little bit of trouble because of inaccuracies or inconsistencies on their customers' cyber insurance applications.
That's a really good one. Real quick on that is every MSP that comes to me and they're like, well, filling them out, the carrier's going to sue the heck out of me. That contract for the policy for your client is between the carrier and your client. But what's going to happen is whenever that does the Travelers thing, or there's another one in the news right now for a breach, the client is going to turn around and sue the hell out of you.
Yeah, exactly. So either way, you're getting sued. It's just a matter of who's suing you.
Yep.
So if you have further questions on the cyber insurance piece, we do host a quarterly session as part of Fireside Chat with the team from Fifth Wall, who brings amazing information every single time. We also ran a 3-part cyber insurance masterclass with them. Shoot me an email if you'd like a copy of that. It's Becky.Teal, like on the screen, at huntress.com. And I'm happy to send you that recording as well. Julie, Eric, Dustin, thank you all so much for your time today. This was incredibly informative. And now I can more confidently answer some of these questions when I get asked, why won't you provide things? Because we get asked too. So thank you as always, and appreciate it. And see some of you very soon on the road, some of you in a few months, but it'll be soon.
Thank you so much for having me.
Awesome. Thank you, everyone.
Thanks, everyone. Bye-bye.
Thanks, guys. Bye.
I don't know how to hang up. There we go. It's ending. All right. I still don't know how to hang up. So we're live. Oh, no, we've ended. Okay, good deal. Thank you, guys. We're closing.
You.
Thanks,
Awesome.
Becky.
Thanks, guys. Have a good
Take
day.
care. Bye.
Bye.